So far left is defense, closest to us is prosecution. All right, they see the string with the stick.
Okay, so all the attorneys, the judge. do not. So this is gonna have to be fixed, but because of the situation,
Yeah, it's just
we
I
have
need
to
get-
wait.
I just don't want to break it down when I'm doing this.
Yeah,
I know I have to move.
I understand that. I would have had this much more organized. And this is gonna happen every single time, and Martha should have told you. So,
Yeah, she didn't tell me.
okay, well, this
Or
is.
I would have checked with my engineering and said, I will do this.
Okay, well, I figured it out, and this is going to, I'm gonna be here every single day doing the same thing.
I guess so.
Different crew
So,
you're designing.
perfect, so Martha should let them know that I'll be here.
Because there was a tree stuck in his car, he thought he was flat down. Yeah, just do hot tires. I mean, it's a bit of a little bit. My kid's 18, so. Yeah, your kid's 18, that's fine. I was surprised when we go out and get wasted, so I think I'm good. Yeah, it's probably, they're not gonna get better than 20 days. Good job. It was not fair.
Yeah. Okay, so I had it on 9:20.
No,
Yeah.
9:20.
Okay, that's close to mine.
So
I have this 9:21. Oh,
you have 9:20.
no. No, it's 9:29.
Yeah.
9:20, 29.
Okay.
I cannot see.
If we have time.
Oh my God, you know what? I just like totally spaced out. I put in that and I just thought I was done. Yeah. I was like, I was saying this kind of. That's good.
9:21.
That's true. That's true. That's true. Okay, what's this one?
Okay, next one is 9:23.
Okay, I have 9:22. Okay, I'm gonna go to 9:23. Just tell me. Just tell me.
Now, 23.
Yeah.
Well,
It seems to be just we're saying that
it's 9:30.
Please rise, por favor. On the record in case number 2023-026, State of Arizona versus George Allen Kelly, the record has shown the presence of all counsel and the defendant and all of the jurors. Ladies and gentlemen, I'm now going to give you some preliminary jury instructions. You should all have a copy of that was provided in your notebook. You're welcome to follow along as I read them, or if you prefer, just to listen along. Good morning again. I'm on what's marked as page 2. Jury service is an important part of our system of justice with a long and distinguished tradition in American law. From the beginning, American law has viewed the jury system as an effective means of drawing on the collective wisdom, experience, and fact-finding abilities of persons such as yourselves. While it may be an occasional inconvenience or worse, jury service is an important responsibility for you and one which I'm sure you will take seriously. Now that you have been sworn, I will briefly tell you something about your duties as jurors and give you some instructions. At the end of the trial, I will give you more detailed instructions, and those instructions will control your deliberations. It will be your duty to decide the facts. You must decide the facts only from evidence produced in court. You must not speculate or guess about any fact. You must not be influenced by sympathy or prejudice. You will hear the evidence, decide the facts, and then apply the law I will give to you to those facts. That is how you will reach your verdicts. In doing so, you must follow the law, whether you agree with it or not. You must not take anything I may say or do during the trial as indicating any opinion about the facts. You and you alone are the judges of the facts. You will decide the facts from the evidence presented here in court. That evidence will consist of testimony of witnesses, any documents or other things that are received into evidence as exhibits, and any evidence stipulated to by the parties or that you are instructed to consider. You may hear reference to exhibits that are not admitted and are not asked to be admitted. These exhibits are not admitted as evidence, but the information from them that is testified to by witnesses is evidence that you may consider. You will decide the credibility of the witnesses and the weight to be given to any evidence presented in court, whether it is direct or circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is a physical exhibit or the testimony of a witness who saw, touched, smelled, or otherwise perceived an event. Circumstantial evidence is the proof of a fact or facts from which the existence of another fact may be determined. The law makes no distinction between direct and circumstantial evidence. You must decide the weight to be given to all the evidence without regard to whether it is direct or circumstantial. I'm going to just step away from the text for a minute. I've been told that that particular instruction with this, how to explain direct or circumstantial evidence, is not very clear. So let me just do it by way of example so you understand the difference. And the point of this instruction is so that you understand what circumstantial evidence is and that it's equally admissible as direct evidence. So what's direct evidence? Someone were to come in a courtroom and say, it's raining outside, and I just came in, I'm soaking wet, it's raining outside. That's direct evidence. Someone is telling you what they just saw, heard, or experienced. Right? Direct evidence. What's circumstantial evidence? If you walk out at the lunch break and you've been inside here all day and all the cars are soaked and there are water puddles everywhere and everything is wet, you can infer from those facts circumstantially that it rained. You didn't see it, no one came in here and told you they saw it or experienced it, but you can tell everything's soaked, the cars are soaked, it rained. That's circumstantial evidence. And each are entitled to equal weight, but the weight to be given to any evidence is up to you. All right? So hopefully that clarifies that a little bit. So we should be at the top of page 3 if you're following along in your books. During the trial, the lawyers are permitted to stipulate that certain evidence exists. This means that both sides agree that the evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. As I mentioned earlier, it is your job to decide from the evidence what the facts are. Here are 6 rules on what is and what is not evidence. You must determine the facts only from the testimony of witnesses and from exhibits admitted into evidence. Anything else that you may see or hear when the court is not in session, even if what you see or hear is done or said by one of the parties or by one of the witnesses, is not evidence and must not be considered by you. If you should hear or see anything pertaining to the case outside the courtroom, or if anyone should attempt to speak to you about this case outside the courtroom, please report it to me through my bailiff as soon as you can. Statements or arguments made by the lawyers in the case are not evidence. Their purpose is to try to help you understand the evidence and the law. A question is not evidence. A question can only be used to give meaning to a witness's answer. If a lawyer objects to a question and I do not allow the witness to answer, you must not try to guess what the answer might have been. You must also not try to guess the reason why the lawyer objected in the first place. At times during the trial, the evidence may be offered, and I do not admit it as evidence. When evidence is not admitted, you must not consider it for any purpose. At times, I may order that some evidence be stricken from the record. Then it is no longer evidence, and you must not consider it for any purpose. Admission of evidence in court is governed by the rules of law. I will apply those rules and resolve any issues that arise during the trial concerning the admission of evidence. If an objection to a question is sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit is offered into evidence and an objection to it is sustained, you must not consider that exhibit as evidence. If testimony is ordered stricken from the record, you must not consider that testimony for any purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility of the witnesses, or give weight, or the weight you should give to any evidence that has been admitted. The rule of exclusion of evidence, the rule of exclusion of witnesses is in effect and will be observed by all witnesses until the trial is over and a result is announced. This means that all witnesses will remain outside the courtroom during the entire trial, except when one is called to the witness stand. They will wait in the areas directed by the bailiff unless other arrangements have been made with the attorney who has called them. However, both the defendant and the state are nevertheless entitled to the presence of one investigator at counsel table, and the victim has a right to be present during the trial. The rule also forbids witnesses from telling anyone but the lawyers what they will testify to or what they have testified to. If witnesses do talk to the lawyers about their testimony, other witnesses and jurors should avoid being present or overhearing. Let me stop for a second again. We have a question from one of the jurors, and the question, which has been distributed to the council, was a question about the presence of a detective at the prosecution table. This particular instruction should answer that question. Both sides are entitled to have an investigator or assistant at the trial to assist them in the handling of evidence, the discussion of evidence, for whatever purpose, even if they're a witness. And the state has one of their investigating officers, maybe their lead investigating officer, at the table with them, even if you may be a witness, and that is permitted by law. And a victim also has the right to be present if they wish. Right? Does that satisfactorily answer the question, Counsel?
Yes, Your Honor. Yes.
Great, thank you. Okay. The lawyers are directed to inform all their witnesses of these rules and to remind them of their obligations from time to time as may be necessary. The parties and their lawyers should keep a careful lookout to prevent any potential witnesses from remaining in the courtroom if they actually enter. From time to time during the trial, it may be necessary for me to talk with the attorneys out of the hearing of the jury, either by calling a conference at the bench when the jury is present in the courtroom or by calling a recess. Please understand that while you are waiting, we are working. The purpose of these conferences is not to keep relevant information from you, but to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. We will, of course, do what we can to keep the number and length of these conferences to a minimum. I may not always grant an attorney's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or of what your verdict should be. Please do not be concerned with what we are discussing at any bench conference we may have. Please respect the privacy of those participating in the bench conference in order to maintain the fairness of the trial. In deciding the facts of the case, you should decide what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the tests for accuracy and truthfulness that people use in determining matters of everyday importance in everyday life, including such factors as the witness's ability to see or to hear or to know the things the witness is testifying to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial, or by other evidence, and the reasonableness of the witness's testimony when considered in the light of all the other evidence. Consider all of the evidence in light of reason, common sense, and your experience. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also give reasons for those opinions. Expert testimony should be judged by you just as any other testimony. You are not bound by it. You may accept it or you may reject it in whole or in part. And you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. At the end of the trial, you will have to make your decision based upon what you recall of the evidence, so you should pay close attention to the testimony as it is given. Now, you have been provided with notepads and pens, and there are scraps of paper there for questions, such as the one we already received. They should be there in the box. The court encourages you to take notes during the trial if you wish to do so. Do not let your note-taking distract you so that you miss hearing or seeing other testimony. You may use your notes during your deliberations at the end of the trial. Until then, keep your notes to yourself. During recesses in the trial, you may leave your notes on your seat. Your notes are confidential, and my bailiff will guard them. No one will be allowed to read your notes. Whether you take notes or not, you should rely upon your own memory of what was said and not be overly influenced by the notes of other jurors. After you have rendered your verdicts, the bailiff will collect your notes and we will destroy them. Do not be influenced at all by my note-taking at times. What I am writing down may have nothing to do with what you will be concerned with at your trial. I'm now going to say a few words about your conduct as jurors. I'm going to give you some do's and don'ts, mostly don'ts, in which I will call the admonition. Do wear your juror badge at all times in and around the courthouse, so everyone will know that you are on a jury. Each of you has gained knowledge and information from the experiences that you have had prior to this trial. Once this trial has begun, which is now, you are to determine the facts of this case only from the evidence that is presented in this courtroom. Arizona law prohibits a juror from receiving evidence not properly admitted at trial. Therefore, do not do any research or make any investigation about the case on your own. Do not view or visit the locations where the events of the case are alleged to have taken place. Do not consult any source, such as a newspaper, a dictionary reference manual, television, radio, the internet, any locations or sites on the internet, or any other electronic media for information. If you have a question or need additional information, submit your request in writing, and I will discuss your request with the attorneys. Do not talk to anyone about this case or about anyone or anything that has to do with it. And do not let anyone talk to you about those matters until the trial has ended and you have been discharged as jurors. This prohibition about not discussing the case includes using email, Facebook, Twitter, instant messaging, Google, Yahoo, or any other internet search engine or any other form of electronic communication for any purpose whatsoever as it relates to this trial. This includes, but is not limited to, blogging about the case or your experience as a juror on this case, discussing the evidence, the lawyers, the parties, the court, your deliberations, your reactions to testimony or exhibits, or any aspect of this case or your courtroom experience with anyone whatsoever until the trial has ended and you have been discharged as jurors. Until then, you may tell people that you are on a jury, and you may tell them the estimated schedule for the trial, but do not tell them anything else except to say that you cannot talk about the trial until it is over. And if anyone gets upset about that, a spouse, significant other, whoever, you tell them that you're following the orders of the judge. Right? One reason for these prohibitions is because the trial process works by each side knowing exactly what evidence is being considered by you and what law you are applying to the facts you find. As I previously told you, the only evidence you are to consider in this matter is that which is introduced in the courtroom. The law that you are to apply is the law that I will give you in the final jury instructions. This prohibits you from consulting any outside source. If you have cell phones, laptops, or other communication devices, turn them off and do not turn them on while in the courtroom. You may use them only during breaks, so long as you do not use them to communicate any matter having to do with this case with anyone else. You are not permitted to take notes with laptops, tape recorders, or any other electronic device. You are only permitted to take notes on the notepad provided by the court. Devices that can take pictures are prohibited and may not be used by you for any purpose. It is your duty not to speak with or permit yourselves to be addressed by any person on any subject connected with this trial. If someone should try to talk to you about the case, stop him or her or walk away. If you should overhear others talking about the case, stop them or walk away. If anything like this does happen, report it to me or any member of my staff as soon as you can. To avoid even the appearance of improper conduct, do not talk to any of the parties, the lawyers, the witnesses, or any media representatives about anything about this case until the case is over. Even if your conversation with them has nothing to do with the case, you should avoid it. For example, if an attorney should pass you in the hall and there's some discussion about where to eat, and someone from a distance may think you are talking about the case. So again, please avoid even the appearance of improper conduct. Lawyers and parties have been given this same instruction about not speaking with you while you are a juror. So do not think that they are being unfriendly to you. When you go home tonight and family and friends ask you what the case is about, remember to tell them that you cannot speak with them about the case. All that you can tell them is that you are on a jury, the estimated schedule for the trial, and that you cannot talk about the case until it is over. In a civil case, which this is not, the jurors are permitted to discuss the evidence during the trial while the trial progresses. In a criminal case, which obviously this is, however, the jurors are not permitted to discuss the evidence until all of the evidence has been presented and the jurors have retired to deliberate on the verdict. You may not discuss the evidence among yourselves until you retire at the close of the case to deliberate on your verdicts. Therefore, during breaks and recesses, whether you are assembled in the jury room or not, you shall not discuss any aspect of this case with each other until the case is submitted to you for your deliberations at the end of the trial. Again, if you have a question or need additional information, please submit your request in writing, and I will discuss that request with the attorneys. During the trial, you are not to engage in any conduct that impairs or interferes with your ability to hear and understand the court proceedings. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all of the evidence, the closing arguments, and the rest of the instructions I will give you on the law. Keep an open mind during the entire trial. Form your final opinions only after you've had an opportunity to discuss the case with each other in the jury room at the end of the trial. Please advise me in writing immediately if you believe that any other juror has violated any prohibition or provision of this admonition. Before each recess, I will not repeat every time the entire admonition I have just given you. I will probably refer to it like saying, please remember the admonition, or something like that. However, Even if I forget to make any reference to it, please remember that this admonition still applies at all times during the trial. There may or may not be news media coverage of this trial. What the news media covers is up to them. If there is news media coverage, you must avoid it during the trial. If you do encounter something about this case in the news media, or on social media for that matter, end your exposure to it immediately and report it to me as soon as you can. If there are cameras in the courtroom during the trial, do not be concerned about them. Court rules require that the proceedings be photographed or televised in such a way that no juror can be recognized. Deputies are assigned to the courtrooms by the sheriff's office. A deputy's presence in the courtroom should not be considered by you for any purpose and should not influence your view of the evidence and should not impact your deliberations in any way. If at any time during the trial you have difficulty hearing or seeing something that you should be hearing or seeing, or if you get into any personal distress for any reason, raise your hand and let me know. If you have questions about anything like parking or where to eat or other matters related to jury service, feel free to ask one of the court staff. But remember that this admonition applies to all our court staff as it does to everyone else, so try not to discuss it with the court staff. If you have a question about the case, and by the way, we're at the top of page 8, just in case you got lost, which happens. If you have a question about the case for a witness or for me, write it down, but do not sign it. Hand it to the bailiff. If your question is for a witness who is about to leave the witness stand, please signal the bailiff or me before the witness leaves the stand. The lawyers and I will discuss the question. The rules of evidence or other rules of law may prevent your question from being asked. If the rules permit the question and the answer is available, I will ask the question of the witness and an answer will be given at the earliest opportunity. When we do not ask one of your questions, it is no reflection on the person who has submitted it. You should attach no significance to the failure to ask one of your questions. I will apply the same legal standards to your questions as I do the questions asked by the lawyers. If a particular question is not asked, please do not guess why or what the answer might have been. All right, so here's the process on questions. Arizona law, there's a very good thing. It allows jurors to ask questions. That's what I just told you. So how does that work? These little slips of paper all over the place. Witness will testify on direct examination, whoever called the witness, cross-examination by the other side, redirect by the side who called the witness. The lawyers ask all the questions first. Then I'm going to turn to you. And I'm going to say, any questions? Does the jury have any questions? And that's when you've got to raise your hand and give us the slips. All right, so you should be prepared for that. So have those little slips of paper and try to write the questions down as they occur to you while the witness is testifying. Because once the lawyers are done, then I'm going to look to you for your questions. And then I'll discuss the questions with the lawyer just as the instructions state. All right? And once that witness leaves the witness stand, that witness may be excused. So if the witness leaves and the witness is excused, that's the opportunity, your opportunity to ask the witness questions may have been lost. It was likely lost. Okay? All right, so let's go back to page 8, where it says, the law provides for a jury of 8 persons in a case such as this. We have 12 jurors, so we have more than 8 jurors, and that's so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. At the end of the case, alternate jurors will be determined by lot in a drawing held in open court. Please do not be concerned with who may or may not be chosen as an alternate at the end of the case. Just to be clear, right now there's 12 of you, only 8 are going to deliberate, but an alternate has not been assigned. So you're all eligible jurors for deliberation. We just draw it out of a paper cup at the end. So you're all right now eligible to be jurors for full deliberations. Okay, a defendant in a criminal case has a constitutional right to not testify at trial, and the exercise of that right cannot be considered by the jury in determining whether a defendant is guilty or not guilty. If there is testimony in this case about what a defendant said to a law enforcement officer, you must not consider any such statements unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement to a law enforcement officer was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or indirect promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. The state has charged the defendant with a crime. The charge is not evidence against the defendant. You must not think the defendant is guilty just because the defendant has been charged with a crime. The defendant has pled not guilty. The defendant's plea of not guilty means that the state must prove every part of the charge beyond a reasonable doubt. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. The state has the burden of proving the defendant's guilt beyond a reasonable doubt. In civil cases, which this is not, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based upon your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In deciding whether the defendant is guilty or not guilty, please do not consider the punishment. All right, we discussed, let me go back. This is the reasonable doubt, the presumption of innocence is one of the most important values, concepts, and principles of law that we have in our legal system. So Mr. Kelly sits here today, he is presumed innocent. We discussed this a little bit yesterday when we asked you questions as jurors. Remember again, if I ask each of you to have to vote right now, guilty or not guilty, or I just don't have any information or enough information, I can't make that decision. Most people choose the latter answer. I haven't heard anything, so I can't make that decision. Seems like a reasonable answer. Unfortunately, not unfortunately, fortunately, it's the wrong answer. Because I just told you, he's innocent. He's presumed innocent. As I said yesterday, it's like he has a cloak around him that he is innocent. That cloak can only be removed if you find that the state has presented evidence that you think is worthy of consideration, that is proof beyond a reasonable doubt of his innocence. All right? Does anyone have any questions about that principle?
I think you misspoke, Your Honor. I think you meant of his guilt.
I misspoke.
I think you misspoke there at the end. If the state provides information of his
Well,
guilt.
good. Thank you for correcting me. If the state provides evidence that you believe worthy of consideration, considering these rules, and you find that the state has proven the case beyond a reasonable doubt, that is when you vote guilty. If you find that the state has not met its burden of proof beyond a reasonable doubt, and you are not firmly convinced of the defendant's guilt, then you must vote not guilty. All right? I apologize for messing that up. All right, back to the instructions. Spanish may be used during this trial. The evidence you are to consider is only that provided through the official court interpreters. Although some of you, or many of you, may know Spanish, it is important that all jurors consider the same evidence. Therefore, you must accept the English interpretation, and you must disregard any different meaning. The court interpreter is required to remain neutral and to interpret between English and Spanish accurately. Must not give interpretive testimony any greater or lesser weight than you would if the witness had spoken in English. It is important that each juror reach a decision based upon the same set of facts. The possibility that a word or phrase may have another meaning is not a topic for discussion unless it is raised by counsel and resolved by the court. Therefore, you must consider only the English interpretation, disregarding what you heard in Spanish. You may not comment to other fellow jurors on what you heard in Spanish. Additionally, you may not retranslate for other jurors testimony that has been translated by the court interpreter, because that would be providing your fellow jurors with information that is not on the record. To assist you in considering the evidence that will be presented during the trial, I will now tell you about the crimes with which the defendant is charged. The defendant is charged with the following offenses. 1, second-degree murder. Second-degree murder requires proof of the following. The crime of second-degree murder requires proof of one of the following. 1, the defendant intentionally caused the death of another person. Or 2, the defendant caused the death of another person by conduct which the defendant knew would cause death or serious physical injury. Or 3, under circumstances manifesting extreme indifference to human life, the defendant recklessly engaged in conduct that created a grave risk of death and thereby caused the death of another person. The risk must be such that disregarding it was a gross deviation from what a reasonable person in the defendant's situation would have done. The defendant is separately charged in count 2 with aggravated assault. The crime of aggravated assault requires proof of the following. 1, the defendant committed an assault, and 2, the assault was aggravated by the following factor: that the defendant used a deadly weapon or dangerous instrument. Assault, which is a component of count 2 of aggravated assault, requires proof of the following: that the defendant put another person in reasonable apprehension of imminent physical injury. The defendant has pled not guilty to these charges. The state must prove each of the charged crimes beyond a reasonable doubt. I will give you more details and information about each of the alleged crimes in the final instructions. The trial is expected to last through February 19th, 2024. That's an estimate, and we will do our best to move the case along, but delays may frequently occur. Those won't be anyone's fault, so do not hold them against the parties. Delays will usually occur because the attorneys and I often may need to resolve certain legal matters before these matters may be presented to you in court, or because I may be busy with other matters. The usual hours of the trial will be from 8:30 to 4:30. We will take short recesses about every mid-morning and mid-afternoon, and may occasionally take stretch breaks in place. We will recess at 12 p.m. and begin at 1:30 p.m. unless a different starting time is announced prior to recessing for the evening. You may assume a starting time of 8:30 a.m. for the next day. At the beginning of the day, please assemble in the jury room for this division. Please do not come back into the courtroom until you are called by the bailiff. And that's, as I mentioned yesterday, Tuesday through Friday. Monday is a day off. All right, we're on the top of page 12, and we're almost finished. Criminal trials generally proceed in the following order. First, the prosecuting attorney will make an opening statement, giving a preview of the case. The defendant's attorney may make an opening statement outlining the defense case immediately after the prosecutor's statement, or the defense may postpone its opening statement until after the state's case has been presented. What is said in opening statements is not evidence, nor is it argument. The purpose of an opening statement is to help you prepare for the anticipated evidence. Then, second, the state will present its evidence. After the state finishes the presentation of its evidence, the defendant may present evidence. If the defendant does produce evidence, the state may present additional or rebuttal evidence. With each witness, there is a direct examination, a cross-examination by the opposing side, and finally redirect examination. This usually ends the testimony of that evidence. Third, after all the evidence is in, I will read and give you copies of the final jury instructions. Those are the rules of law that you must follow in reaching your verdict. Fourth, the attorneys will make closing arguments to tell you what they think the evidence shows and how you should decide the case. The state has the right to open and close the argument since the state has the burden of proof. Just as in opening statements, what is said in closing arguments is not evidence. Finally, you will deliberate in the jury room about the evidence and the rules of law in an effort to reach your verdicts. If you unanimously agree upon the verdicts, they will be read in open court with you and the parties present. And finally, you will be discharged and released from all admonitions. The rules of law that I have shared with you in the past few minutes are preliminary only. At the end of the case, I will read to you and give you a copy of the final instructions of law. In deciding this case, you must be guided by the final instructions. All right. The final 2 pages are another way of state the admonition. And I'm not going to read those now. I'll read those at an appropriate time. That's what I told you yesterday. All right. Looks like one of the jurors has a question. Before we go any farther. Counsel, hopefully you still have your headsets in front of you. Apparently, one of the jurors caught me in another mistake, and I really appreciate it. Thank you. This trial will, I guess I said the trial will last through February 19th. It should last through April 19th. That's when the instruction. So thanks for the correction. And obviously shows that people are paying close attention. So I'm going to mark the first question as question number 1. I'll mark this. It's not really a question, it's a correction. This is question number 2. Now give us the clerk to file it. And the state may make this opening statement, either Ms. Hunley or Mr. Jennings.
Thank you, Your Honor. On January 30th of 2023, at 2:30 in the afternoon, George Allen Kelly walked out of his house armed with an AK-47 semi-automatic assault rifle and a .40 caliber handgun. And he opened fire on an unarmed man and an unsuspecting man. Can y'all hear me better now? As I was saying, Mr. Kelly, armed with an AK-47 semi-automatic assault rifle and a .40 caliber handgun, walked out of his house and opened fire on 2 unarmed men who were unsuspecting. Those men were 115 yards away from Mr. Kelly and his residence. That's the length of a football field. Those men, Daniel Ramirez and Gabriel Quinn Bucumea, posed no threat to Mr. Kelly and no threat to his wife. They were walking parallel to the Kelly residence, headed back to the United States-Mexico border. Before firing on those men, George Allen Kelly gave no verbal warnings of any kind. He had no interaction of any kind with these men. Out of nowhere, without saying a thing, without any legal justification, George Allen Kelly let off a barrage of semi-automatic assault rifle fire at these 2 men. He stood on his back patio and he shot that semi-automatic assault rifle through the patio where he keeps his horse, across another fence line, and across a dirt road, and into the back of Gabriel Quinn Boogeyman. Now, Daniel Ramirez was just steps away from his companion when he saw Gabriel shot in the back. And he saw Gabriel fall to his death. Daniel had to run for his life because the shots were still ringing out all around him. The state anticipates that Daniel will come here to tell you about what happened to him that day. Ladies and gentlemen, that is state versus George Allen Kelly in a nutshell. On the screen you see in front of you, on your right, you see a still photo of the video interview of George Allen Kelly on the day of the murder. On the left is a photograph of the view from George Allen Kelly's back patio as you look out toward the area where Gabriel fell and died. This is a photograph of Gabriel Quinn Boogeyman. And I'm going to ask you to do something in this case that George Allen Kelly's own words tell you that he did not do. I'm going to ask you to consider Gabriel Quinn Boogeyman as a person, as a human being, and not as George Kelly described him, as an animal. Now, again, this is the view from George Allen Kelly's patio. You'll see you're looking out from his patio, out past his gazebo, and towards that pasture area I described a minute ago. And it's past that pasture area, past a dirt road, is where Gabriel fell and died. I want to show you the view from the other direction. This is the view through the pergola, or the gazebo, and back toward the area where George Allen Kelly was standing. And you'll see in that photograph, sort of on the right, as you look through the gazebo, a door. That's not the main door into the residence. There are actually two doors on this back patio. There's another door that's directly behind that umbrella. And we'll show you another picture later that shows that door, but that's actually the door that George Kelly came out of. To the left of that in the photograph are two windows. Those are the windows to the living room area, and behind the living room area is actually the kitchen area. This is a photograph of the semi-automatic assault rifle, AK-47, that George Allen Kelly shot and killed Gabriel Quinn Boogeyman with on January 30th. And I want to point out a few features on this weapon. There's a green strap on the weapon, and these details become relevant when you hear the officers talk about what they observed George Kelly carrying later on in the day. So there's a green strap on the handgun, pardon me, and you'll see that there are some wood features on the AK-47 also, and that the metal on the weapon is a little bit aged from use. So you can kind of see that, I think they call it bluing, a little bluing on the weapon. And if you look on the front end of the weapon, you'll see that taped with black electrical tape is a flashlight with an orange button on it. And just below the AK-47 is what's referred to as the magazine. Sometimes it's called the clip because that's what holds the bullets that clips inside the gun. And that magazine holds 30 rounds. And rounds are what they refer to, how you refer to the bullets that go into an AK-47. They're called rounds. So this AK-47 holds 30 rounds. It also holds 1 round inside the weapon itself for a total of 31 rounds. And you'll hear from the experts in this case that this entire magazine can be expelled, can be shot within less than 6 seconds. This is just the other side of the AK-47 for you to see, and a better view of that green strap that we referred to earlier. This is the .40 caliber handgun that George Kelly had on his hip that day when he exited his house. Now I want to go back to this view from George Kelly's patio, because there may be something that you didn't notice about this photograph. And that is that off in the distance, there is a detective standing in this picture wearing a black polo shirt and a tan pair of pants. He's not a small detective. He's about 6 feet tall. He's a good-sized detective. And that detective is standing in the spot where Gabriel fell and died in this case. And that red circle with the red arrow is pointing you to where the detective is. And if you still can't see it, that yellow arrow is now pointing directly at the detective. That's how far Gabriel and Daniel were when the defendant opened fire on them that day. Now I want to turn to the area where Gabriel's body was located. This is a photograph of Gabriel's body in place. And what you see in this photograph, first I want to point to the background of the photograph. You see some lights in the background? That is the Kelly residence. And so you can see them sort of off at the top part of the photograph, off in the distance. Now below that, and just in front of that, you see a tree. Now keep your eye out for that tree, because we're going to go through some other photographs and some drone footage later, and you'll want to have that as a marker when you're looking for things. In the foreground of the photograph is Gabriel's body, and you'll see that the grass was very high, and probably about 2 feet at the time, and it's that yellow straw grass. And you can see that Gabriel's body was very difficult to see in that terrain. Gabriel is wearing some tan boots, some tan pants, an olive-colored jacket, and a camouflage backpack. This is a close-up, closer-up picture of Gabriel. Again, you can see the tan boots, the tan jacket, or the tan pants, pardon me, the olive-colored jacket, and you can see a camouflage fanny pack along his side. And you can see the camouflage backpack, which is kind of up over his head. And you can see from these photographs that Gabriel is unarmed. There are no weapons in these photographs. There were no weapons located near Gabriel's body. In this photograph, you can see the blood seeping through Gabriel's jacket on his back where he was shot. And Gabriel was shot here on his back. And this is a close-up of the gunshot wound. You can see the gunshot You can see the gunshot entry wound on his green jacket. And you can see that the blood has seeped around on the jacket. Also in this photograph, you can see that strap from the fanny pack that's down along the side. In addition to the, let me just try to switch out here. We'll see if that works any better. Sorry for the interruptions, folks. You can also see in this photograph that Gabriel has a radio on his waist. So you can see the black antenna from the radio sticking up on the side of him.
And now I kind of want to give you some perspective on what we're looking at here. We looked at those photographs. We talked about what the terrain looks like. But you'll learn during this trial that we asked for some assistance from some other agencies. One of those agencies is the Department of Public Safety. And they have an aerial drone footage. And they came out with their aerial drone and they took some video footage and some photos of the terrain. And you'll see on the left, there's and what that drone footage allows us to do is take really accurate measurements from those photographs. And you'll see they're overlaid on a computer screen. The officer who operates those aerial drones will be able to give you some real good idea how those work. But essentially, what the trooper did is he ran that aerial drone over the area, and it gives you sort of like a bird's eye view of what that area looks like. And if you take a look, it's kind of hard to see in the photograph on your left, but you'll see that there's an up and down line in blue, and that's the north-south line. And you'll see a line that goes left and right. That's your east-west line. That's in red. And the green line is measuring the distance from Kelly's back patio where he shot to the area where the victim's body was located. And it's kind of difficult to see the end of the green line, but can you see it's on the other side of that dirt road? That's the location where Gabriel's body was found. Now on your right, you'll see the still shot of the aerial drone footage. I'm going to play that aerial drone footage for you, but it goes kind of quick, so I want to give you a little bit of a preview of what you're going to see. What you're looking at right now is like 3/4 of the top of the Kelly residence, and you can also see the Kelly back patio there. You'll see there's a fountain. You might want to keep that in your mind as a reference when you're looking at some of these photographs. And to the right of that, you see some orange cones. It's sort of in that general vicinity that George Allen Kelly shot that day. And those are where we took the measurements from on the patio, was from those orange cones. And you'll learn throughout the trial that to the right of the orange cone is the area where the spent shell casings were located in this case. So just to give you some orientation on what you're looking at and what you're going to hear during the trial. But just past this patio, you'll see the gazebo that we saw in the other photograph. Then you'll see a pile of metal structure on the right. It's some kind of smoking pit. And then you'll see a pile of wood just before a fence line. Then you'll see a pasture where the defendant keeps his horse. You'll see the second fence line. And then you'll see the dirt path just past that. And then it's past that you see the tree we saw in the photographs, and then 4 orange cones that depict the area where the victim's body was located, where he fell and died. So we're looking at the top of the house. That's the orange cones. We're going through the pergola. There's the wood pile in the first fence line. And it's kind of difficult to see, but if you keep your eyes peeled, you'll start to see now the second fence line, and it sort of goes up at an angle to your left. And now you see the dirt road and the tree and the 4 cones where Gabriel fell and died. And don't worry if you missed that second fence line. We're going to play another video that goes a little bit slower, and you can have a better look. So on to the next video. Again, you see that same diagram on your left, and on the right is the second drone video. So we're looking again at the top of the Kelly roof, and then we're going to see that same thing, that patio, the pergola or gazebo, and the smoking pit is that metal thing. Then you'll see the the pile of wood, the fence line, and then keep your eyes peeled for a little bit for that second fence line and then the dirt road. And there are your orange cones, the gazebo, the first fence line, and then now you can see the second fence line. And you can see it sort of goes off diagonally toward the road. Everybody see that? And then you see the dirt road and the four cones where Gabriel's body was located. And now just to sort of give you some orientation, because we looked at those photographs and we saw that Gabriel was shot here, and you could see that the house was this direction, and we know he was shot in the back. But to kind of give you perspective, we know that he fell forward onto his face into the dirt. And so to give you just, and this is not to scale, this is just for demonstrative purposes so you get an idea of the orientation of the body. You can see that small little person we added there to that screen. That shows you the orientation of the body. So he was face down, head to the south, and feet to the north, with the bullet entry lined up with the back of the Kelly house where Kelly shot from. Now, based on all of this information and based on what happened that day, George Kelly was charged with two things. He was charged with second-degree murder, and he was charged with aggravated assault with a deadly weapon. The second-degree murder relates to the death of Gabriel, and the aggravated assault with a deadly weapon relates to the shooting at Daniel. So, second-degree murder is one of the more complicated crimes, lucky you all, but it's what's called a unified offense. That means there's three ways that the state can prove second-degree murder. You all don't have to agree on which theory of second-degree murder the defendant committed. You only have to agree that he committed one of these theories of second-degree murder. And you all have to be unanimous that he committed the murder. You can just decide that there are different ways in which he committed it. So I'm going to talk to you about the three ways that the state can prove during this trial that the defendant committed the murder. The first way is by proving that the defendant intentionally killed Gabriel Glenn Buchanan, that he shot him, that he intentionally shot him, and that he caused his death. The second way is the state can prove that Kelly caused Gabriel's death by conduct that he knew would cause death or serious physical injury. So those are the two simple ways. The third way is the more complicated way, but it's also the easiest way. So we can also prove that the defendant committed second-degree murder by, under circumstances manifesting extreme indifference to human life, he recklessly engaged in conduct that created a grave risk of death and thereby caused Gabriel's death. So that he behaved recklessly, manifesting an extreme indifference to human life, and that he created a grave risk of death and did cause the death. And the risk has to be such that disregarding it was a gross deviation from what a reasonable person would do in the circumstances. So that's second-degree murder. One of those three ways is how the state proves that the defendant committed second-degree murder in this case. And I submit to you that the facts of this case, the defendant is guilty on all three of those theories. The second count is aggravated assault with a deadly weapon. And in aggravated assault with a deadly weapon, the state has to prove that Kelly intentionally placed Daniel in reasonable apprehension of imminent physical injury. In this case, that's by the conduct of shooting a gun in his direction. That would place anyone in reasonable apprehension of imminent physical injury. That means that they think they're about to get injured. That's pretty much what that means. And that he did so using a deadly weapon. We know he used his AK-47. And now I want to talk to you a little bit about the area where this occurred and sort of orient you on what was happening that day. This is just a map of Santa Cruz County, just to give you an idea of the location where this happened. We're in Nogales. We can see that on the map there. We're in the area that's a little bit white. All the major residential areas in the county are on here: Rio Rico, Tubac, Sonoita, Elgin, and you can see those all on the map. You see the area circled in yellow. That is Keno Springs. That is the area where this event took place. And this area, this is a close-up of the area that's at issue, which is really just south of the Keno Springs residential area. And you'll see to the right on this map in white is an area called Pedregoso Tanks. That's an area that's in the National Forest. And as I said, Keno Springs is, the residential part of Keno Springs is just to the north of this. And Nogales, where we are today, is just to the west of this area. And to the northeast of this area is Patagonia. And you'll see along the bottom here is the United States-Mexico border. And you'll see this area where the arrow points is right where the border wall ends. You'll see like a dirt road that comes right up from the map. Where that arrow points, that the border wall ends, that is right where the border wall ends, right where that road comes directly up from the end of the border wall there. Over on the right of this map is the National Forest. And the National Forest, right where the border wall ends, is where the National Forest begins. And on January 30th of 2023, let me go back to that map for a second. Daniel Ramirez and Gabriel Quinn Butimea were with a group of undocumented migrants, illegal immigrants, who crossed the border illegally at the end of the border wall. And they crossed the border really early that morning, and they hiked up into the National Forest. And they've been hiking all day in that area. And you're gonna meet Daniel. Daniel's gonna come here and testify. And you're gonna learn that Daniel is a really humble guy. Daniel comes from Honduras, and Daniel had spent many years in Mexico. He has a 5th or 6th grade education, and he generally works as a farmhand in a small village in Mexico. And you'll learn that, obviously, for someone with his educational background and with his occupation, he struggles to get by in off-season. And in sometime before January of 2023, he was working a masonry job during the off-season in Nogales, Sonora, and he met Gabriel Quinn Butimea. And he and Gabriel started talking about getting work in the United States as a roofer. And as they talked, Daniel decided that sounded like a good idea, and so he paid illegal folks to come across the line illegally. He paid a fee to come across the line. And you'll hear that Daniel was traveling across and up and through the National Forest that day with Gabriel and with a group of men, about 7 or 8 people altogether. And they were traveling up through the National Forest. They traveled most of the day. It was about 2 o'clock in the afternoon, and they encountered some Border Patrol officers. And so they decided to scatter. They took off running all in different directions. Gabriel and Daniel stayed together, and they decided they were going to go back into Mexico and just give this a try another day. And so they were running, fleeing from Border Patrol, running pretty fast for about a half an hour. And it was at about that time that they decided they were going to take a little bit of a rest. They were worn out from running. They're headed back to Mexico, and they're going to slow down and take a rest. And Daniel didn't even have time to register that there was a residence around. The only thing Daniel saw was a red horse, a skinny red horse. And he saw that horse off to his right. He's walking along a dirt path. Dirt path is sort of off to their right. And he sees this skinny red horse off to his right. And they're walking along, and they see this skinny red horse. And out of nowhere, a barrage of semi-automatic assault rifle fire comes their direction. And they're walking, and Daniel sees Gabriel just a few feet ahead of him get hit in the back with the assault rifle fire, and he sees him grab his chest and say, "I'm hit," and he sees him fall in front of him and die. And then Gabriel, because the shots are still ringing out all around him, takes off running and runs for the border, running for his life. Now at around 2:30 that day, George Kelly came to his house to have some lunch. And he was in his kitchen making his lunch at his kitchen island when he sees something outside that catches his attention. And just started to give you a little bit of an idea, George Kelly's house is about a little less than 1.5 miles from the United States-Mexico border. His property is about 170 acres, and it's surrounded by a large ranch, the Buena Vista Ranch. The Buena Vista Ranch is on the west side of his property, so the Nogales side, and the south side of his property. On the east side of his property is National Forest, and to the north is that Keno Springs residential area. Excuse me. And George Kelly was in his house that day making his lunch when he saw something outside that caught his attention. Instead of calling 911, he has his .40 caliber handgun on his hip. He goes to his back door, grabs his AK-47, and tells his wife to call the Border Patrol. To call the Border Patrol ranch liaison specifically. And his name is Jeremy Morcell. And so Wanda Kelly picks up her phone, calls the Border Patrol, and George Kelly goes outside and lets off a barrage of semi-automatic assault rifle fire. These are the two weapons that George Kelly had that day. We've already talked about those. And again, this is the view from George Kelly's back patio where he went out and let off that semi-automatic assault rifle fire. And that's the area where Gabriel and Daniel were, that Gabriel fell and died. This is Jeremy Morcell. Jeremy Morcell is that ranch liaison that George Allen Kelly's wife called that day. The job of a ranch liaison is kind of just what it sounds like. Border Patrol needs to have access to properties that are close to the border in order to do their work. And so they work hard to have good relationships with people who are near the border. And the ranch liaison's job is to facilitate that access to those properties, to work with the residents to have them allow the Border Patrol to have access, and also to facilitate communication with those folks, to make sure those folks know when there's an operation going on so they can stay out of the way, so they don't put themselves in the middle of an operation, And so that the homeowners can communicate with the Border Patrol if there's any information that they want to pass on to help Border Patrol with their job. So that's what Jeremy Morcell's job is. So this day at 2:30, George Kelly calls Jeremy Morcell. And he says to George, "I'm being shot at and I'm shooting back." He says, "I can't talk right now. There's 5 people all running southbound with packs." And Jeremy Morcell will tell you that during that phone conversation, George Kelly was very rushed and very frantic on the phone call. And you're going to wonder, Kim, why are you giving me all these details about these phone calls and these statements? It's because throughout the day, these stories shift from moment to moment with Mr. Kelly. And it'll be important for you to take good notes about what Mr. Kelly says and when he says it and when that story changes, because that's a shifting story throughout the day. So that was the first call. While that call is happening, Agent Morcell is talking to the appropriate people in his dispatch center, making sure that Border Patrol gets dispatched out, and also making sure the Sheriff's Department gets dispatched out, because Mr. Kelly has said there's a shooting going on. About 2:36, Jeremy Morcell calls Kelly back. At this time, Kelly gives him a slightly different story. He tells him he had an altercation with these people, and they're headed toward Keno Springs, which is now the opposite direction that he said during the first phone call. And he says something about maybe they're trying to circle back or something of that nature. He says on this call, not I'm being shot at and I'm shooting back, but I heard a gunshot in my direction. And he saw his horse running by. And it's unclear in this phone conversation, is he outside when he hears the gunshot, or is he inside when he hears the gunshot? And that changes again later, whether he's inside or he's outside when he hears this alleged gunshot. A gunshot, by the way, that no one else hears other than George Allen Kelly. When he's on this conversation at 2:36 with Jeremy Morcell, he says that he's inspecting his horse and that it doesn't look like his horse was shot. Now, the horse is going to be important because you're going to hear from Daniel about the horse and how Daniel believes that the horse got shot. And he believed at the time that the horse got shot, and he thought the horse saved his life. From his view of what was happening at that time, that's what he thought happened. And clearly, George Allen Kelly also thought something happened to his horse because he's busy inspecting him at this point. George said that, and this is the important piece of this phone conversation, the people were too far away to tell if they had any kind of firearms. 115 yards away, they were too far away to tell if they had any firearms. George Allen Kelly could not tell if they had any firearms. And we saw that from the picture we saw a few minutes ago about the location where Gabriel fell and died. During this phone conversation, he was quite a bit calmer than he was during that second phone conversation. So the next thing that happens is officers have been dispatched out, and the Border Patrol gets there really quick. They're there within about 10 minutes. This is a pretty remote area, so that quick of a response time is pretty great. So when the Border Patrol arrives, the first Border Patrol agent, there's 2 Border Patrol agents in total who go out to the scene during this first call for service, and 5 sheriff's deputies respond. When the first deputy arrives, or the first Border Patrol agent arrives, he learns that Mr. Kelly is headed south in the property, that he's taken off south from his house on the property. And before they go looking for Mr. Kelly, they decide they're going to search the area of the house for any kind of immediate danger. So they kind of split up. Actually 6 of them, because the 5th deputy doesn't get there until pretty much everything's done. So the 6 of them split up. They search that immediate area, the pasture by the house. They search the area around the house. And they tell Mrs. Kelly, stay in the house. We're going to go look around. The Border Patrol agents head off. They just sort of hike straight across the property, and you'll see that they locate Mr. Kelly about a quarter mile south of the house, not far from a barn and a mechanical pump house. Like, it's a pump house where you pump water from a well in the ground. So it's got a little pump house. And it's down in that area that the Border Patrol find him. And when they do find him, by the way, they see him walking with his dogs. He's carrying an AK-47, and they don't locate anyone else. None of the deputies, none of the Border Patrol locate anyone else while they're there. This is a map just to give you an idea of the Kelly property. And you'll see at the top of the map in white is the Kelly residence. You'll see that area in blue is the area of the residence. And around the edge of the blue line is about where Gabriel's body was located. The area in green is the barn. They have a big metal barn. It's that metal barn near that area, and this yellow circle is the pump house. Where those are, just to give you an idea. And you'll see that there's a dirt road that goes through the property. That's just the Kellys' sort of driveway through their property. And you'll also see in this map that there's a wash that runs through the Kelly property. You can kind of see that in the drone footage we looked at. Off in the background, you can see a little piece of the dirt road, and you can see the wash that's kind of down below. But those are just some items for you to have an idea of, so that they may become important during the trial.
Ms. Aldean, court reporter's been going for about an hour and a half, and they need a break, as do the interpreters. We've been going too much farther beyond that, but all the data we have suggests generally that we've prone to mistakes. So we'll take a 10-minute recess, and we'll continue with the opening statement. Right.
I think it's working okay.
Okay, I just want to make sure.
Still not silent. Maybe you want to wait till the lunch break,
Okay,
and
and then
we'll
I'll
have a little more time.
Yeah, because I would like to.
I could have waited 5 seconds.
I'm sorry, I had no idea where I was with engineering.
Yeah, and I told Lacey, I said, hey, Julia, I'll just take her in. But yeah, Martha should tell you guys.
Yeah, I mean, I can give you
I'm not in charge of that, it's Lacey, and she talks directly to Martha.
Well, there's at the John Parodies that had
Saw any body. I just saw a body. And then he goes on to say, and from what in that I only approached the body to make sure that the animal, it's not a vegetable or a mineral, the animal wasn't alive, and it was not alive. There was no signs of blood. There was just an animal laying face down, an animal. And you know what an animal is. It's not a vegetable or a mineral. It's a body. And you know what I'm talking about. But I think more than the words of what he said to dispatch, when you hear the tone of what he says during this call, you'll see the impact of what it is that he's saying.
Hello?
Hi, sir. I'm calling from the Tucson Sheriff's Office.
Yes.
Hi. I'm just calling because we received the report from Border Patrol.
Yes.
So I'm just calling to get more information. So what happened?
You're going to have to send an officer out here.
Okay, what's going on?
I can't.
I'm sorry?
It's very serious, ma'am, and I can't. I'm not going to talk over the telephone.
Okay, I understand it's serious, but I need more context in order to send a deputy.
Okay, fine. It's going to be.
Go ahead,
well,
you can talk to me. What's going on?
Yeah, I know I can talk to you, but you're responsible for what I say, and I'm responsible for what I say.
Can you give me a little context of what happened? What's going on? You told them
I'm
that
not.
what did you shoot at?
I didn't shoot at any. I haven't said I shot at anything.
Okay, well, that's what Border Patrol told us, so that's what I'm just asking you.
Yeah. Y'all guys, the Nogales Sheriff Department had 4 or 5 guys out here this afternoon investigating a Border Patrol drug running incident. And I don't know if I can't remember the officer's name. There was 2 gentlemen and 2 young ladies. And they third. Do you know who I'm talking about? They came out to 100 Willow Cross Circle.
You mean for my deputies, correct?
And yeah, they were Nogales.
Yeah, I'm aware of what happened earlier.
You're aware? Okay, then they're aware of what happened, and I don't want to get you in trouble, and I don't want to get me in trouble, but I don't want to break the law or anything like that. So what I'm telling you is that we need a sheriff deputy out here, 100 Willow Cross Circle, immediately, and that's all I can say, ma'am.
Okay, is anyone hurt? I need to know because if someone's hurt, I need to send an ambulance too.
There's no.
Okay, do you feel more comfortable talking to a deputy over the phone?
Well, in other words, okay, you know the thing. You have the right to remain silent, and anything you can,
I understand.
anything you say can and will be held against you. And I'm not admitting to anything I've done, but all those things tend to add up, and I don't know what happened. I just know what I just saw about 15 minutes ago, and it's something that an ambulance cannot help. EMTs cannot help. There's nothing out here that can be aided by EMT or emergency services.
Okay, I understand you don't want to give me a lot of details, but you are requesting an officer from me, so I needed to know for their own safety and your safety a little bit of what's happening, what's going on.
Okay, I'll put it like that or not?
Yes, sir. I'm aware of what happened.
Okay, it's a situation similar to that. How's that?
Okay.
You follow it? You understand what I'm saying?
I
It's a
understand what you're
situation
saying.
exactly like that.
Okay.
And so that's going to require the sheriff to come out here.
Okay. Can you tell me a description of the
No,
vehicle?
I don't have a description. There's not a vehicle.
Okay.
The only thing that I was referring to in conjunction with that accident was the body.
Okay.
You got it?
Okay. All right. Okay. Can I have your name?
Yes, George Kelly.
George Kelly. Okay, George. Would you, if my deputy goes over there, would you take him to whatever it is that you found?
Yes. I have it marked. I have a flashlight on over it because it's going to be dark when he gets here probably. But I'll take it to him.
And you are sure an EMT cannot help?
I am positive. I have a medical background. An EMT cannot help.
Okay. Do you know whoever it is that you saw?
No, I do not know. I didn't say it was anybody. I just said it was a body.
Okay. All right. Okay. All right.
I'm not trying to be smart, ma'am. I'm just trying to.
You're trying to be careful, and I get that. However, I hope you understand that on my end, I have to take care of my deputies too. So I
Yes, I
needed a
understand.
little bit more context as to why you needed a deputy to head out there.
Now you know that there is a body here.
Okay. All right. Does it look somewhat?
And it's not alive. So you asked, did you need EMT? I said no.
Okay.
Not sure. A coroner will be involved sooner or later.
I understand. George, can you tell me something? Is it discolored from somewhere?
Is it discolored?
Yes.
What does that mean?
Has it been there for a while? Can you tell?
From what? In that I only approached the body to make sure that the animal, it's not a vegetable or mineral, the animal wasn't alive and it was not alive.
Okay.
There were no signs. There was no signs of blood. There was just an animal laying face down.
An animal?
An animal, and you know what an animal is. It's not a vegetable or a mineral.
Okay.
It's a body, and you know what I'm talking
I
about.
understand what you're talking about, George. Okay, I'm going to send the deputy then over to your house so you can lead them over to wherever you found what it is.
Okay.
Okay?
And now, maybe one of the deputies are out here. They know how to get here because it's 100 Willacross Circle, and it's kind of hard to find. It's a rat right on the border.
So I have one of my deputies that responded earlier going over your way.
That's good. You do that. They know how to get here, and I'll have the gate open.
Okay, sounds good, George. Thank you. Thank you for that.
I appreciate your help and your patience, and I'm sorry if
No problem. I accept.
Okay.
Okay.
Bye.
Thank you.
Bye.
Bye-bye.
It was just a few minutes after that that the first deputy arrived for this second call for service. And that was Deputy Rafael Lopez. And Deputy Lopez had responded to the scene earlier in the day, but he was one of the later deputies. He was that later deputy who got there after really everything had finished up earlier in the day. And what Deputy Lopez did when he got there was he turned on his recorder. And he recorded, as soon as he arrived at the scene, for a few minutes of what George Kelly was reporting to him. And this is that recording.
Afraid somebody had shot. Some of there was a shot fired, and I didn't know what it was about. Okay, so I went out to get the horse. I always bring him in and feed him. Put him in another pasture. I went out there to get him. And y'all guys, you weren't over here? Yeah, I was here. Y'all walked all over that. And the Border Patrol walked all over. And maybe this happened after you left. I don't know. There's a body right now. And I don't. Yes. About fresh. I didn't, as soon as I saw it, I backed away from it. The line flicked face down. It's big. The body, the person,
Shortly after this, Sergeant Omar Rodriguez arrives at the scene. And Sergeant Rodriguez meets up with Deputy Lopez and George Kelly by a horse trailer that's down by a gate into the pasture area of where the horse was kept by the house. And when Sergeant Rodriguez arrived about 6:15, he saw that Kelly was wearing that Glock handgun still on his hip. And he asked Mr. Kelly if he would be willing to take that handgun off for officer safety reasons and leave it behind in the trailer. And Mr. Kelly agreed to do that. He took the weapon off and left it in his horse trailer that's right next to the gate in that pasture area. From there, Kelly took Rodriguez out to the body. And they walked around on that dirt path that goes around from the driveway that you saw, that dirt road, that's the driveway. They took the dirt path around the outside of the pasture back to where the body was located. And they found the body near that tree that we saw, and the defendant had hung up a flashlight in the tree so that they could locate it, because it was starting to get dark at this point. And as I mentioned before, the sergeant found the Gabriel's body laying face down with his head toward the south, with his face implanted in the dirt. And his legs were towards the north. So, and we showed a little picture of that earlier on how the body was positioned. And when Sergeant Rodriguez got a good look at the body, he could see the gunshot entry wound in Gabriel's back, and he could see that was on the right side of his body, which then lined up with the Kelly's residence. Later, they were able to look and discover that the gunshot exited from the chest. He made a number of other observations about the body. He saw that there was no pulse. The extremities were cool, but the torso was still a little warm to the touch. He looked around the area because of the story that Mr. Kelly had about these other people and things of that nature. He looked around and he saw there weren't any drag marks. There wasn't a blood trail. There was nothing to indicate there were groups of people nearby. He saw nothing like that in the area. And nothing at all that indicates that a body had somehow been dumped there or anything of that nature. It appeared to Sergeant Rodriguez as if Gabriel had fallen there and died. And he noted, as I said before, that gunshot wound generally lined up with the trajectory to where George Kelly was shooting from on his back patio. And again, just a reminder of the photograph of how he found the body. And I think we've already gone through all this, but it kind of shows you where that gunshot wound was lining up with the residence. And again, just the body positioning with that tiny little stick figure to just show you how the body was laying with the gunshot entry on the house side. Now, a little while later, after they do their investigation there at the scene and they gather the information about what had happened earlier in the day from all their sources, George Kelly is transported to the sheriff's department for an interview. He's read his Miranda rights, and a video interview is conducted of him. And this is the still shot from that video interview that happened about 8:29 p.m. that night. So we're talking maybe 6 hours after the homicide. And you'll learn that during that interview, George Kelly tells Detective Ainsa that he was eating lunch in the kitchen, and when he looked out through the living room window, and he heard a shot. Now he's in the house when he hears the shot. Before he's outside when he hears the shot. He hears a shot. It's It's close, and he sees his horse running by. He says about 100 to 150 yards out, he sees men running with tan shirts and pants with a full brown, big, solid backpack on. He then clarifies that he saw them, and then he heard the shot after he came outside. And he says that he saw them run into the arroyo. He told this whole story without admitting that he shot his AK-47. Never admitted he shot his AK-47. It was about 30 minutes into the interview, and after Detective Ainsa pressed him about conversations that Kelly had earlier with Agent Morcell, when George Kelly finally admitted he shot his AK-47 that day. He says to Detective Ainsa that they were running, and he moves his hand from left to right, parallel with me. They were parallel to the house. I'm telling you the truth, did not make the statement that I shot somebody or shot at, or shot somebody or shot, period. So then he's denying that he even told Agent Morcell that he had shot his AK-47. And when Detective Ainsa presses him and says, "Did you shoot?" George Kelly admits, yes, he shot. And then he claims that he shot over their heads. And when Detective Ainsa asks him, how far were they when you shot him? George Kelly says 150 yards. Well, we know where Gabriel's body was discovered, 115 yards from the back of the Kelly residence. And why did you shoot at them when they were running away from you? Detective Ainsa asked. And Kelly says, because when you're out there in that situation and you have people that they weren't running away from me, they were just running. And you said earlier that they were running away. They were running across, hand moves from, again, his hands moving from left to right, across the wash. And then he clarifies that they were running 100 to 150 yards away again. And then he says, now he says they're armed. And the detective then asks him, when they were running with the rifle, did they ever point their rifle at you? Up until this point, George Allen Kelly has never said a peep about these individuals pointing a gun at him. And we know based on what he told Agent Morcell earlier, that they were way too far away for him to see if they had any handguns or had any kind of weapons. And what Kelly says at this point is he says, if a guy's running and he turns, he's going to turn and he's going to point it at you. Just in a mode of turning, he's going to point it at you. So yes, they turned the rifle and pointed it towards me. And again, that's with the knowledge that we already have, that he already told Agent Morcell that they were too far away for him to tell if they had weapons. So what's important about the statement that Kelly made to Detective Ainsa? He didn't admit he shot his AK-47 until 30 minutes into the interview, and that's because he had something to hide. He knew he'd killed Gabriel. He didn't say anyone pointed a gun at him until Detective Ainsa asked him about it, and he didn't say he was in fear for his life until Detective Ainsa suggested it to him. Now, after this interview with George Kelly, late into the evening of January 30th of 2023 and early into the morning of January 31st of 2023, detectives Ainsa and other members of his team worked to serve a series of search warrants. They served some search warrants on the house, they served some search warrants on the vehicles and the surrounding outbuildings. And you'll hear that during that series of search warrants, they recovered the AK-47 that we showed you in the picture that was used in this incident. They asked for assistance from our small department, so we asked for assistance not just from the Department of Public Safety, but also from ATF. They have a dog that can sniff for explosives and can find spent casings. And so we utilize their canine to look for the spent casings. And in this case, we're talking a very high-powered rifle that went through and through the body and into the desert. That projectile could be up to a mile away. That projectile was not recovered by the ATF canine, and it was not recovered even based on detectives' efforts with a metal detector. The officers did recover 9 fresh AK-47 casings near the back patio of George Kelly's residence. And the first one was actually discovered by the canine. And I'll show you that photograph in a minute. The other 8 casings were discovered by Detective Joe Bunting, who's now Sergeant Joe Bunting. He found those looking during the daylight the following morning. And with him, he also had a metal detector, I believe. But again, because of the terrain and the type of weapon used, the projectile was not recovered in this case. So we talked a little bit about the weapon earlier, the AK-47, and we talked about the bullets or the rounds, but I've been using a phrase that I didn't explain to you, and that is a spent casing. So the bullet or the round has several parts to it. It has the projectile, that's the piece of metal that's on the top that you can see that's shiny on the bullet that's in this picture. And then on the bottom is the darker part, and that part's called the casing. And inside the casing are the explosives that cause the projectile to spew out at the top of the round. And so what's left over and what ejects from the weapon is called a spent casing. That's just that metal piece that's left over that the explosives are now out of and the projectile is not out of. So 9 casings were recovered around the area of George Kelly's back patio. And on the right in these pictures, right, you're right, yes, is the spent casings. On the left, you can see the rounds or the bullets. Now, during that search warrant, I indicated that detectives found the semi-automatic assault rifle, the AK-47. It was in George Kelly's bedroom, and it was behind the door, and it had a sweater over it. George Kelly told the detectives that he always keeps that weapon by his back patio door. It was not there that day when detectives came. And in fact, what you'll hear is that it was really late when detectives were there. They took that photograph on the left the first time they were there, and they left the AK-47 behind. They had to come, during their second search warrant, they came back and recovered the AK-47. But that is the AK-47. It was in the same spot when they came back, and they did recover it during the second search warrant. This is the ATF canine that found the first casing in this case. And you can see the tent, the evidence tent, is where that first casing was located. The next day, you can see detectives have located the other 8 casings in this case. And just to give you an idea where those casings are located, this is just a still shot of that aerial drone footage we looked at. And you can see the yellow circle is where the 8 casings were discovered by the detective. And the one in blue is the one casing that was discovered by the canine.
I'm sorry. It's almost noon. Let's break for the lunch hour. I don't have any additional information about the water situation. Saw my court administrator coming in here. But I doubt it's fixed yet. We're going to break for lunch. Be back in the jury room at 1:30. find out what the water situation is and decide to go from there. But as I said, if they haven't fixed it and are not able to fix it shortly after there, we'll probably just recess for the day. But let's be optimistic about that, and I'll see you back in the jury. We'll see you back in court. Please be in the jury room at 8:30. Please remember the admonition of the court. That applies to break at all times. All right?